If you are a U.S. citizen, a green card holder, or a family member waiting for a visa approval, please take a moment to breathe with me. Just breathe. I want you to picture something for a moment. Imagine you are sitting at your kitchen table on a quiet morning. Your coffee is warm. The house is still. And then your phone buzzes with a headline that says, "Social Security payments are now being linked to immigration status." And just like that, the quiet morning is gone. Your heart is beating faster. You are wondering if your monthly payment is at risk. You are wondering if someone, somewhere, made a decision that is about to change your life without telling you. I know that feeling, and I know why you are here. My name is Piper, and I want to make you a simple promise right now. My goal today is not to give you more anxiety. My goal is to give you the quiet truth. We are going to sit here together, just like two people at a kitchen table, and we are going to go through this carefully, calmly, and honestly. We are going to separate the rumors from the reality, and by the time we are done, I want you to feel something that headlines almost never give you. I want you to feel clarity. Stay with me. Every word of this matters. Before we go any further, I need to be straightforward with you about one important thing. I am your guide today. Not your lawyer, not a Social Security caseworker, not a USCIS representative. What I share in this video is for your peace of mind and your education, explained in plain, simple, human language. If your personal situation requires specific legal or financial guidance, please speak with a licensed professional. That conversation is always worth having. But right now, let me be the calm voice that cuts through the noise. So let us talk about what is actually happening. The headline connecting Social Security payments to immigration status did not appear out of nowhere. It is rooted in a real policy conversation that has been developing over several months, and it involves a specific intersection between two very large government systems, the Social Security Administration and the Immigration Enforcement Framework. And when two large systems start to interact in new ways, headlines get written. Some of those headlines are accurate, some of them are exaggerated, and most of them leave out the most important part, which is context. Here is the context. There has been an ongoing federal discussion about whether the Social Security Administration should more actively share data and records with immigration enforcement agencies. This conversation is part of a broader effort by certain government officials to create what they describe as a more connected federal data system. The idea, in its most basic form, is that different government agencies would have greater access to each other's records in certain circumstances. Now, a federal court, doing exactly what courts in this country are designed to do, has been asked to examine parts of this data-sharing framework. The court is essentially looking at the government's homework and asking, was this done correctly? Were the proper legal steps followed before these systems were connected? That review is ongoing. And while it is ongoing, certain parts of this framework are being examined more carefully before they move forward. Think of it this way. Imagine two large filing cabinets in a government office. One cabinet belongs to Social Security. The other belongs to immigration enforcement. For years, those cabinets were kept separate, with very specific rules about when and how information could be shared between them. Now, someone has proposed connecting those cabinets with a new passageway, and a judge has stepped in and said, before you build that passageway, show me the blueprint and prove it was designed correctly. That is what is happening right now. The judge is reviewing the blueprint. The passageway has not been fully built. And your files, your records, your benefits, they are still in their respective cabinets, exactly where they belong. Now let me answer the question that I know is sitting at the front of your mind. Does this affect my Social Security payment? In the vast majority of cases, the answer is no. Let me explain exactly why, and let me be very specific about who is and who is not directly involved in this conversation. Social Security benefits that you have earned through years of working in the United States and paying into the system, are not welfare. They are not a government gift. They are deferred wages. They are money that was taken from your paycheck, month after month, year after year, and held in trust for you until you reach the age of eligibility. That earned benefit has a very different legal standing than a needs-based assistance program. And the policy conversations happening right now are far more focused on needs-based programs than on earned Social Security retirement or disability benefits. This distinction matters enormously, and it is one that headlines almost never make clearly. If you are a naturalized U.S. citizen receiving Social Security retirement benefits that you earned through your work history in the United States, you can rest easy. Your citizenship is established. Your work record is documented. Your benefit is based on contributions you made to the system, not on your current immigration status. The data sharing conversations being discussed do not change the fundamental legal basis of your earned benefit. If you are a long-term green card holder who has been working legally in the United States, paying Social Security taxes, and who is approaching or already receiving retirement benefits based on that work history, you can rest easy. Your contributions to the system are on record. Your eligibility is based on those contributions, and your legal permanent residence, provided it is current and valid, does not put your earned benefits at risk under the current framework being discussed. If you are a senior who has been receiving Social Security for years without interruption, who has a clean immigration record, and who has maintained your legal status properly, you can rest easy. The system does not reach backward to disrupt benefits that were correctly established and have been consistently paid. That is not how the Social Security Administration operates. I want to say something now that I think is one of the most important things in this entire conversation. There is a critical difference between earned benefits and means-tested programs. Earned benefits are things like Social Security retirement, Social Security disability, and Medicare Part A, which is the hospital insurance portion of Medicare. These are programs you paid into. They are based on your work record and your contributions. They are not charity. They are not subject to the same eligibility debates as programs that are funded purely through general government revenue. Means-tested programs, on the other hand, are programs where eligibility is based on your current income and financial need, regardless of whether you paid into them. Programs like supplemental security income, which is SSI or Medicaid or certain housing assistance programs. These programs have always had more complex rules around non-citizen eligibility, and it is in this space, the means-tested space, where the current policy conversations are most active. If you are receiving SSI specifically, and if you are a non-citizen receiving SSI, this is an area where it is worth speaking with a benefits counselor or an immigration attorney to understand your specific situation. Not because anything has definitively changed today, but because this policy space is active and evolving, and being informed about your specific situation is always better than being caught off guard. Now let me talk about something that I know many of you feel deeply: the fear of the unexpected letter. You know the one I am describing. The letter that arrives without warning. The letter that uses official language you do not fully understand. The letter that makes you wonder if something is about to be taken away. And when headlines suggest that Social Security and immigration systems are being connected, that fear of the unexpected letter gets louder. I want to offer you something real about that fear. Government benefit changes, when they happen, do not occur without a documented process. They do not happen silently, overnight, without any form of notice. The Social Security Administration, by law, is required to notify beneficiaries of changes to their benefits. That notification must include the reason for any change, the effective date, and information about how to appeal or request a review. That is not optional. That is a legal requirement that exists specifically to protect you. So if you receive a letter from the Social Security Administration, read it carefully. Do not panic. Do not assume the worst. Read the letter, understand what it is asking or telling you, And if you do not understand it, take it to a trusted source: a legal aid organization, a senior services center, an immigration attorney, and get help understanding it before you respond. The letter is not the end of the story. It is the beginning of a process that you have the right to participate in. The United States is like a very large ship. It does not turn quickly. It does not make sudden, sweeping changes to the lives of millions of people without process, without notice, and without the opportunity to respond. That is not how it operates. That is not how it was built. And when someone tries to make it turn too quickly, the courts exist precisely to slow that turn down and make sure it is done correctly. Now I want to speak directly to the seniors watching this video. Those of you who are 65, 70, perhaps 75 years old. Those of you who spent decades working in this country, paying your taxes, contributing to the system, raising your families, building your lives. Those of you who are now depending on the benefits you earned and who look at headlines like today's with a deep, personal fear that goes beyond policy and touches something much more immediate. Your anxiety about this is completely understandable. When you have worked for something your entire life, the thought of it being threatened, even the possibility of it being threatened, is deeply painful. I acknowledge that. I do not minimize it. But I also want you to hear this clearly. The law is on your side. The Social Security benefits you earned through your work are documented in a federal record that has your name, your work history, your contribution amounts, and your eligibility determination. That record does not disappear because a policy is being reviewed. It does not get erased because two government systems are having a conversation about data sharing. The law is on your side. Time is a factor. Policy conversations take time to resolve. Court reviews take time to complete. And during that time, silence and uncertainty can feel unbearable. But the structure of your earned benefits remains. The legal protections around them remain. And the law is on your side. I also want to normalize something that I know causes a particular kind of daily suffering. And that is waiting for information that does not come. You watch the news. You follow channels like this one. You look for updates. And sometimes the update is simply that there is no update yet. The court is still reviewing. The policy is still being examined. The agencies are still in conversation. And that uncertainty, that ongoing, unresolved state of not knowing, is genuinely hard to live inside. But here is what I want you to hold on to during that waiting. No news is often just processing news. The absence of a definitive change, in most cases, means that the existing framework is still in place. Your benefit is still being calculated the same way. Your status is still being evaluated the same way. The system is still operating under the rules that were in place when your benefit was established. Silence from the government is not always an omen. Sometimes it is simply the sound of a very large, very slow system doing its work. The mail might be slow. The online portals might not have new information. The phone lines might give you general answers. That is the system being what it is: large, slow, and occasionally frustrating. But that slowness, again, is your protection. A delay is the system being slow. A denial is the system saying no with a specific, documented reason and a pathway to appeal. If you have not received a denial, you have not been denied. You are in the waiting, and waiting is not the same as losing. I want to take a quiet moment now, before we close, and simply be honest with you about something. I know you are counting the days. I know the empty mailbox feels heavy. I know that watching a headline about Social Security and immigration in the same sentence does something to you that goes beyond intellectual concern. It reaches into the practical reality of your daily life, your rent, your groceries, your medications, your ability to be there for the people you love. I know that this is not abstract for you. It is real. And I want you to know that the way you feel is completely valid. You are not alone in feeling it. There are millions of people in this country, seniors, immigrants, naturalized citizens, long-term green card holders, who are navigating the same uncertainty, watching the same headlines, carrying the same quiet fear. And those people, like you, did everything right. They worked, they paid in, they followed the rules, they built their lives inside the system, and they deserve, as you deserve, to have that work respected and protected. You are part of a community of people who did things right, and that community is not disappearing. Let me bring us home with the facts, spoken plainly. Here is what we know today. There is an ongoing federal policy conversation about data sharing between the Social Security Administration and immigration enforcement agencies. A federal court is reviewing whether parts of that framework were established correctly and whether proper legal process was followed. That review is a check and balance, and it is the legal system doing exactly what it was designed to do. For the vast majority of Social Security recipients, naturalized citizens, long-term green card holders, seniors who earned their benefits through decades of documented work, this policy conversation does not immediately or directly threaten the benefits they receive. Earned benefits have a different and stronger legal foundation than means-tested assistance programs. And the court review currently underway is specifically examining whether proper process was followed before any changes were made. What you should do is simple. Keep your immigration documents current and organized. Keep your Social Security records accessible. If you receive any official correspondence, read it carefully and seek help understanding it before responding. And if you have specific concerns about your personal situation, speak with a licensed professional who can give you advice tailored to your circumstances. What you should not do is let a headline rewrite the story of everything you have built. Because the story of what you built, the years of work, the contributions, the legal residency, the earned benefits, that story is documented. It is real. And it does not disappear because the news cycle is noisy. The system is large. It is slow. It is structured. And for the people who have done things the right way, it continues to move forward, deliberately, carefully, and with the weight of the law behind it. If this video brought you even a small amount of peace today, I am genuinely glad. Please let me know in the comments below. I read every single one. Your questions shape the conversations we have here, and your presence in this community reminds me every day why this work matters. Stay informed, stay calm, take care of yourself and the people around you, and I will see you in the next update.